the same parties for a payment of money, and one decree is held by one party against the other, and vice versa. Okay. The court may, on application, set off the amounts. The party with larger decree gets execution for the balance. It's like a set off. Okay. Okay. So, okay. So example, XYZ are jointly and severally liable for 10,000 under a decree obtained by A. Y obtains a decree for some amount against A. A may treat his joint decree as a cross decree under under Order 21, Rule 18, and set it off exam tested. Next is Garnishi Order, Order 21, Rule 46. The Garnishi Order is an order issued by the court under Article 21, Rule 46, Order 21, Rule 46, that with Rules 46A and 46I of the CPC, attaching debts due to the judgment debtor in the hands of the third party, the garnishee. Okay. 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 Right. Garnishee, a third party who is instructed by way of legal notice to surrender money to settle a debt or claim. The garnishee owes money to the judgment debtor and is served with the order requiring payment to the decree holder instead. Okay. 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 Detention of judgment debtor in civil prison. Section 51 CPC, Proviso Section 55 CPC 58. Detention of judgment debtor in a civil prison for money decree requires the court to be satisfied of one of the following. Proviso to Section 51 plus Order 21 Rule 37. First one, judgment debtor is likely to abscond or leave the local limits of the court's jurisdiction with the object of obstructing or delaying execution. The second point is missing. Judgment debtor has after the institution of suit dishonestly transferred, concealed, or removed any of his property or committed any act of bad faith in relation to his property. Okay. Judgment debtor has had the means to pay the decree or some substantial part since the decree, but has refused or neglected to pay. Statement 2. Irregularity merely in the procedure of suit.
Mahesh, the statement was removed. వాళ్ళు శివాన వాళ్ళు ఇక్కడ ఎందుకు రిమూవ్ చేశారో రాసిరు. నువ్వు సెకండ్ అది లేదన్నావు కదా. You don't need to read that.
Is not a ground for detention. Irregularity merely in the procedure of suit is not a ground for detention. Okay. So under Order 21, Rule 37, conditions 1, 3, 4 apply for detention. Okay. Maximum period of detention is under Section 58. Okay. Exceeding 5,000, 3 months, 2,000 to 5,000, between 2,000 to 5,000, 6 weeks. Okay. Below 2,000, no detention allowed. Okay. All right. So even if maximum is like 1 crore or something, also that's 3 months. Okay. So decree for 3,500 detention of up to 2 weeks falls within Section 58 of 1 of B. Maximum detention for decree exceeding 5,000 is 3 months. Decree amount below 2,000, judgment debtor cannot be arrested at all. Detention does not discharge the debt. The decree remains enforceable. Judgment debtor may be released on furnishing security or payment. Okay, this is for execution of decree. Distinct from contempt of court, gone by Contempt of Court Act 1971. Okay. Next topic, compensatory costs. Section 35A. Section 35A CPC provides for payment of compensatory costs in respect of false or vexatious claims or defenses. The court may award the compensatory cost if the claim or defense is found to be false or vexatious to the knowledge of the parties setting it up. Maximum amount 3,000 in ordinary cases. This was the figure in CPC. Some answer keys may show 5,000 from earlier amendments. Answer keys vary. The textbook position has been 3,000. Awarded over and above regular costs, compensatory costs. Okay. Costs of causing delay. Section 35B. CPC page number 305, inserted by 1976 amendment. Cost of causing delay can be also avoided. Okay. Next topic, interest, section 34. Section 34 of CPC empowers the court to include interest in the decree. Okay. Interest on the principal sum from the date of institution of the suit to the date of decree. Further interest from the date of decree to the date of payment or the other date specified. Court has discretion as to rate subject to statutory caps. Okay. Next. Right. Costs, section 35. Okay. Section 35 CPC, costs are in the discretion of court. Costs include witness expenses, legal fees, and other expenses incurred in connection with the proceedings. Costs do not include personal footing and lodging expenses of parties exam tested. These are not incidental personal costs, not awardable, not awardable as costs of suit. Next, surety, section 145. 145 CPC, where a person has become a surety by furnishing security or bond to the court in any of the three capacities, the surety may render himself liable. Clauses 1, 2, 3 of section 145. A payment of any money or performance of any decree. Okay. For restitution of property taken in execution. Okay. For payment of money or fulfillment of any condition imposed on a person under any order of the court. So under section 145, a surety may be liable in all three capacities. Okay. Exam tips 3. Section 2, CPC, decree. Preliminary, final, or party, both. Section 2 of 3, decree holder, any person in whose favor decree is passed. Section 2 of.
Mahesh, నేను చెప్తాను ఇక్కడి నుంచి. ఓకే.
Hmm.
Okay, there are some people who have joined lately. Just summarize చేస్తాను. Basically, what's happening here is we are talking about execution of decrees. Execution of decrees అంటే in the civil suits, somebody says this land belongs to me and the other person wins the case, but the other person is in possession. So there is an execution to get that land on his name. So there are multiple things. One is registration ఉంటుంది, తర్వాత పొజిషన్ ఉంటుంది. There are multiple things that are involved in execution of the decree. So మీరు కేసు గెలిచినా కూడా ఈ డిగ్రీని ఎగ్జిక్యూట్ చేయండి అని యూ హావ్ టు గో టు ద కోర్ట్ టు గెట్ యువర్ థింగ్స్ డన్. సో ఇన్ దట్ మల్టిపుల్
if it doesn't automatically do, right?
Correct. So there are multiple sections in this thing. So section 2 of CPC, initially when we have learned, it is basically the basic decree. What is a decree and an order we have learned in the initial sections. The 2-3 is decree holder is a person in whose favor the decree has been passed. Okay, and the section 212 is basically what Mahesh was talking about, which is mesne profits. Profit from wrongful possessions plus interest, not improvements. Okay, wrongful possession lo unna atanu is gaining profits anamata. And section 5, which is basically recovery of immovable property by CPC procedure. సో ఇదేంటంటే ఇమూవబుల్ ప్రాపర్టీని ఎట్లా రికవర్ చేయాలి, వాళ్ళు అన్నట్టు వాళ్ళు రిజిస్ట్రేషన్ చేయట్లేదు ఆర్ సంథింగ్ ఈజ్ నాట్ హ్యాపెనింగ్, దెన్ యూ కెన్ యూజ్ దట్. అండ్ ఆర్టికల్ 136 లిమిటేషన్ యాక్ట్, సో ఎగ్జిక్యూషన్ విత్ ఇన్ 12 years. సో వాట్ ఎవర్ ఈజ్ అ డిగ్రీ మీరు ఆ 12 years లోపలే ఎగ్జిక్యూట్ చేయించుకోవాలన్నమాట. అండ్ సెక్షన్ 51 మోడ్స్ ఆఫ్ ఎగ్జిక్యూషన్, which is basically delivery, attachment and sale, arrest of the receiver and other things. And the Order 21 Rule 18 cross decrees, which is again what Mahesh was talking about. The cross decrees is setting off. A may treat joint decree as a cross decree. And Order 21 Rule 46 garnishi order attaches debts owned to judgment debtor by third party. So garnishi is equal to third party owning money to, what is JD, Mahesh? Judgment debtor.
Judgment debtor. Judgment debtor.
Serve to surrender to decree holder. సో ఎవరైతే డబ్బులు అప్పున్నారో జడ్జిమెంట్ ప్రకారం వాడు డబ్బులు అప్పున్నాడు కాబట్టి వాడు జడ్జిమెంట్ డెటార్ అనమాట. యాజ్ పర్ ద జడ్జిమెంట్ హీ ఈజ్ అ డెటార్. అండ్ వేరియస్ టైప్
జడ్జిమెంట్ డెటార్ కి ఇంకొకళ్ళు అప్పున్నారు, జడ్జిమెంట్ డెటార్ కి ఇంకొకళ్ళు అప్పున్నారు. సో ఈ డిగ్రీ ప్రకారం వాడు అప్పున్నాడు ఇస్తాడు ఫైన్ లోన్కి, అంతే కదా.
జడ్జిమెంట్
డెటార్ owes money to decree holder.
కరెక్ట్. నువ్వు కన్ఫ్యూజ్
థర్డ్ పార్టీ ఎవరైతే నేను జడ్జ్మెంట్ డేటర్, నువ్వు డిగ్రీ హోల్డర్ అయితే నాకు వేరేటోడు అప్పించేవాడు ఉన్నాడు, వాడిని నీకు ఇవ్వని చెప్తాడు డైరెక్ట్. దట్స్ గార్నిష్ ఆర్డర్.
కరెక్ట్ కరెక్ట్ సార్, కరెక్ట్. నెక్స్ట్ సెక్షన్ 58 డిటెన్షన్. ఇప్పుడు ఏంటంటే 5,000 పైన అయితే సివిల్ ప్రొసీజర్స్లో యూజువల్లీ డిటెన్షన్ ఉండదు, బట్ ఇన్ సర్టన్ సిచ్యువేషన్స్ వేర్ 5,000 పైన అయితే 3 months మ్యాక్సిమం డిటెన్షన్ ఇవ్వచ్చు. 2,000 లోపల అయితే అసలు డిటెన్షన్ అలౌడ్ కాదు. అండ్ 2,000 to 5,000 ఉంటే 6 weeks కన్నా ఎక్కువ ఇవ్వద్దు అనమాట డిటెన్షన్ ఇన్ వెరీ రేర్ కేసెస్. అండ్ ఆర్టికల్ 21 ఆర్డర్ 21 రూల్ 37 డిటెన్షన్ గ్రౌండ్స్ ఏంటంటే అబ్స్కాండింగ్, ఫ్రాడ్యులెంట్ ట్రాన్స్ఫర్ చేసిన, రెఫ్యూజల్ టు పే, డిస్పైట్ డబ్బులు ఉన్నా కానీ పే చేయకుంటే ఇవన్నీ డిటెన్షన్ గ్రౌండ్స్ అనమాట. అండ్ సెక్షన్ 35 which is basically deals with costs, does not include food and lodging. So basically what are these costs? Section 35 కింద ఇప్పుడే నేర్చుకున్నాం మనం. చెప్పగలరు ఎవరన్నా? సో బేసికలీ ఇప్పుడు వాట్ ఈస్ హ్యాపెనింగ్ ఇస్ కాస్ట్ ఆర్ ఇన్ డిస్క్రిప్షన్ ఆఫ్ ద కోర్ట్. కాస్ట్ ఇంక్లూడ్ విట్నెస్ ఎక్స్పెన్సెస్, లీగల్ ఫీస్, అదర్ ఎక్స్పెన్సెస్ ఇన్కర్డ్ ఇన్ కనెక్షన్ విత్ ద ప్రొసీడింగ్తో ఏమైతే ఉన్నాయో అవి. సో వన్ ఆఫ్ ద థింగ్స్ యూ హ్యావ్ టు రిమెంబర్ ఈజ్ ఇప్పుడు అరే లీగల్ పైసలు కూడా ఇవ్వాలి అని రాపించుకున్నారు అనుకో, కాస్ట్ డు నాట్ ఇంక్లూడ్ పర్సనల్ ఫుడ్ అండ్ లాడ్జింగ్ ఎక్స్పెన్సెస్. సో ఇది ఎగ్జామ్లో అడిగిన క్వశ్చన్. సో దీస్ కాస్ట్ డు నాట్ ఇంక్లూడ్ పర్సనల్ ఫుడ్, లాడ్జింగ్ ఎక్స్పెన్సెస్. లాయర్కి ఇచ్చిన పైసలు, విట్నెస్లు తీసుకొచ్చే పైసలు ఇవన్నీ కౌంట్ అయితే కానీ ఇవి కౌంట్ కావు. అండ్ ద అదర్ వన్ ఇస్ సెక్షన్ 35A, కాంపెన్సేటరీ కాస్ట్ ఫర్ ఫాల్స్ వెక్సేషియస్ క్లెయిమ్స్. సో దెర్ ఈస్ అ సెక్షన్ 35A విచ్ ఈస్ బేసికలీ కాంపెన్సేటరీ క్లెయిమ్స్ ఇస్తారు. మ్యాక్సిమం 3,000 పర్, మ్యాక్సిమం 3,000 ఉంది. కొన్నిట్లో AIBలో 5,000 కూడా చెప్పారట. సో ఇది మనం ఒకసారి వెరిఫై చేసుకోవాలి. Okay. And section 34 is interest in decree, and section 140 is surety liability under bonds, instruments, or security. Clauses 1, 2, and 3. Detention does not discharge the debt. So person entitled for the possession of specific immovable property may recover in the manner provided by the code of procedure. So let's come to the questions in this thing. So first question is, a person entitled to the possession of specific immovable property may recover in the manner provided. సో ఆయనకి డిగ్రీ వచ్చింది, స్పెసిఫిక్ ఇమూవబుల్ ప్రాపర్టీ రికవర్ చేసుకోమని. సో ఏ ప్రొసీజర్ ప్రకారం వెళ్తారు ఆయన? కోడ్ ఆఫ్ ప్రొసీజర్ యాక్ట్, ఇన్ ఇండియన్ రిజిస్ట్రేషన్ యాక్ట్, ఇండియన్ కాంట్రాక్ట్ యాక్ట్, ట్రాన్స్ఫర్ ఆఫ్ ప్రాపర్టీ యాక్ట్. బేసికలీ ఇట్స్ కోడ్ ఆఫ్ సివిల్ ప్రొసీజర్ ఓన్లీ కదా. కోడ్ ఆఫ్ ప్రొసీజర్ రాసిండు, బట్ యాక్చువల్లీ ఇట్స్ కోడ్ ఆఫ్ సివిల్ ప్రొసీజర్, సెక్షన్ 5. నెక్స్ట్, మెస్నే ప్రాఫిట్స్ ఆఫ్ ప్రాపర్టీ మీన్స్ వాట్? So those profits which the person is in wrongful position of such property actually received or might have received therein, the profits due to improvements made by person in wrongful positions, both A and B. And none of the above. So why it is not B?
So improvement, profit made up by improvements is not considered as a profit.
Okay. So only wrongful position of actually received. Improvements దానికి కౌంట్ కాదు, అంతేనా? ఓకే, నెక్స్ట్ డిగ్రీ హోల్డర్ మీన్స్
Who holds the decree? In whose favor the judgment is made.
Whose favor a decree has been passed.
Oh, హేమాలి గారు వచ్చారా? ఓకే. And okay, madam. Next question, an order issued by court under Civil Procedure Code 1908 and as per Order 21, Rule 46 for recovery of amount due to judgment creditor is known as?
21 now.
So I think one of the things is
recovery of amount due to judgment creditor.
రూల్ 46 అంటే ఇది బేసికలీ బుక్లో చూడాలి వెళ్ళి, రూల్ 46 ఏముంది అని. సో హియర్ ఇట్ ఈస్ సెయింగ్ గార్నిష్ ఆర్డర్ గురించి డిఫైన్ చేసింది రూల్ 46. సో ఇఫ్ యూ ఓపెన్ దట్ బుక్, వాట్ ఎవర్ బుక్ యూ టేక్ టు ద ఎగ్జామ్, ఇట్ విల్ బి దేర్ ఇన్ దట్ బుక్ యాజ్ అ గార్నిష్ ఆర్డర్. రూల్ 46 అని స్పెసిఫిక్గా చెప్తున్నాడు కదా. ఓకే, నెక్స్ట్ క్వశ్చన్. is basically Mr. X, Mr. Y, and Mr. Z are jointly and severally liable 10,000 on a decree obtained by Mr. A. Mr. Y obtains a decree of 10,000 against Mr. A. As A singly and applies for execution in the court in which the joint decree is to be executed. Which of the following option is correct for Mr. A? So A,
Cross decree.
huh?
Yeah, please continue.
అన్ని క్రాస్ డిగ్రీ కదా.
He may
So
treat his joint decree as cross decree.
What
A
is
may-
cross decree?
It's like a set of, you know, two persons holding a decree against each
Order
other, and
20.
they'll set off.
ఇక్కడ ఉంది order 21 rule 18 XYZ are jointly and severally liable 10,000 on a decree obtained. He may treat his joint decree as a cross decree.
it's
Okay.
it's a kind of set off mechanism where the smaller amount is a set off against a larger decree and the larger decree prevails అన్నమాట.
Okay. Okay.
So I have a decree against Mahesh for 10,000. Mahesh has a decree against me for 8,000. My decree will prevail. ఆ మనీ సబ్ట్రాక్ట్ చేసినాక 2,000 మహేష్ has to give and my decree will prevail.
Oh, okay.
But
Okay.
in this case, three people jointly hold the decree. So నా కాంట్రిబ్యూషన్ ఎంత అది మాత్రమే సెట్ ఆఫ్ అవుతుంది.
Okay.
Okay. So A may treat his joint decree as cross decree because set off అవుతుంది కాబట్టి క్రాస్ డిగ్రీ కింద కన్సిడర్ చేస్తారు. అందులో వాడికి ప్రపోర్షనల్ గా ఎంత ఉందో అది చేసి ఇస్తారు అన్నట్టు వాడికి.
Okay.
Okay. Next, which of the following is not included in word cause as provided under Code of Civil Procedure 1908? So
Putting
ఇందాక
lodging.
ఫుడ్ లాజింగ్ నాట్
Food and lodging.
is actually as per section 35A prakaram food and lodging is not allowed in legal expenses. Okay. And under section 58 of the Civil Procedure Code, what is the maximum period of detention in civil prison for a decree amounting to 5,000?
3 months.
3 months.
3 months. Okay. Which of the following situation within section 58(1) of the Code of Civil Procedure falls within? So decree for 1,800 detention 3 weeks. So ఇందాక కండిషన్స్ చదువుకున్నాం కదా, 5,000 పైన అయితే 3 months, 2,000 నుంచి 5,000 అయితే 6 weeks. So maybe it's B, right?
Second.
Less than 2,000 means no. So 3,500 కాబట్టి 6 weeks.
Okay.
Okay. Next, when a decree is for payment of money, execution by detention in prison shall not be ordered unless after giving the judgment an opportunity showing cause the court is satisfying what? Judgment debtor is likely to abscond or leave the local limits. So one ఎందుకు అరెస్ట్ చేస్తారు? What is the order? Execution by detention అంటే అరెస్ట్ ఎందుకు చేస్తారు? Under. So ఇందాక మనం conditions.
He may abscond, or he can transfer the property, or can damage the property.
Decree or dishonestly transferred any part of the property, and decree if is for a sum which determine a bond fiduciary capacity of an accountant, since means to pay substantial amount of decree and neglected to pay the same.
Second
So-
point low, he transferred the property, but before the decree was passed. So if it has said that after the decree passed, if he transferred, then that is also considered.
Okay.
Mm.
Yeah. So smart question అడిగింది ఇక్కడ. ఏ ఇయర్ అడిగింది ఈ క్వశ్చన్? లాస్ట్ ఇయర్ చూసినావా? లాస్ట్ ఇయర్ AIB 2020లోనే ఇవన్నీ గేమ్స్ ఆడి, where the pass percentage is very less. Okay, which section of CPC provides for payment of compensatory costs? Compensations
35A.
35 legal expenses, food, అది lodging cover గా 35 లో. So according to 35 of civil procedure, what is the maximum amount of court can award as compensatory costs in ordinary cases?
3,000.
3,000.
Some
Okay.
places 3.
Yeah, this was asked in AIB 20 only.
The food lodging expenses.
Okay, and then
Payable
imposition of
the cost.
imposition of compensatory cost in respect of false or vexatious claims or defenses is dealt under.
Same.
35.
35.
Yeah, so 35 is very important. Every year they're asking. Okay. Next, section 34 of CPC provides what? Payment of fine imposed by the court, payment of compensation, payment of interest. None of that.
Payment
So
of interest.
section 34 deals with payment of interest on the decree. Okay. And then again another question on garnishi. A third party who is instructed by the way of legal notice to surrender money to settle a debt or claim.
A.
No. Borrower arrested for defaulting. Okay, A is correct. Yeah. Next, according to the clauses 2, 3, 1, 2, 3 of section 145 of the Code of Civil Procedure, a surety is what?
All of them. Personal liable, he may only give a change upon his property. Personal
So
liability.
clause 1 ఏం చెప్తుంది? Specifically that a surety under such a bond A render himself personally liable. Clause A is personally liable. Clause B is give a charge upon only on his property. Okay, personally liable. Second clause is property. Third clause is basically both undertake personal liability and charge to his property. Is both. So 1, 2, 3. So all of the above. You book specific అడిగినప్పుడు you can just open the book and see, right? And then verify against it. Okay, we'll go to the next topic, which is basically suits by and against government. Hemali garu, మీరు read చేస్తారమ్మా?
Yes, I'll read that.
Yeah, please. Yeah.
Suits by and against the government, section 79 CPC, the special procedural rule. Is there a lot of noise or is it okay?
No, there is no noise. We are okay. Do you want me to mute? Yeah, I can mute. Yeah.
No. I was telling about my background on. Okay. Suits by and against the government, section 79. Special procedural rules apply when the government is a party. Most notably, the mandatory 2-month notice under section 80 before suing the government. So when government is a party, 2-month notice must be given under section 80. Okay. Suits against the government, section 79. Section 79 CPC is in any suit by the government or against the government, the authority to be named as the plaintiff or defendant shall be Union of India. Union of India in central government's case and the state in case of state government's case. This is the names given, either plaintiff or defendant according to section 79. Section 80 of CPC, notice is mandatory. The notice is mandatory at least 2 months. 2 months prior should be given. No suit shall be instituted against the government or against any public officer in respect of any act done by him in official capacity until the expiration of 2 months after the notice is in writing has been delivered to the secretary, to the government concerned or the collector in case of state government or the public officer concerned. Notice requirements intended, it must contain the particulars of the cause of action, the name, place of residence of the plaintiff, relief claimed. Notice period is 2 months. So many times they are given 2 months, 2 months. Okay. Given according to section 80 of CPC. Effect of one more thing is suit can proceed only after the notice requirement is satisfied. Effect of non-compliance. So non-compliance with notice requirement, that is, if you have not given that 2-month period, they have not followed it, it makes the suit defective and liable to dismissal. So according to State of Bihar versus Dhirendra Kumar, section 80 notice is mandatory and non-compliance makes the suit premature and liable to dismissal. So exception is when there is urgent relief. There is an exception also is given in section 80 clause 2. The court may dispense with the 2 months notice if it is satisfied that the case requires urgent or immediate relief. Like everything has an exception, this also has an exception. Section 80 clause 2 if there is any urgent or immediate relief. or the delay would defeat the ends of justice when justice is more important rather than following rules of the 2 month notice. Provisions of Section 80 are binding on all courts hearing suits against the government, that is, binding on all civil courts, including the High Court, District Court, and subordinate courts. Note AIB mark all of the above to the answer to the provisions of Section 80 of CPC are binding on with the options including High Court, Civil Judge, etc., meaning Section 80 binds all forums hearing such suits. All civil courts. Okay. So all of the above pettalannata option if they ask like this. So suits by the government, Section 81. So till now we read about 79, 80. I think notice period. 80 clause 2 is the exception of if there's any urgent relief needed, and 81. So government can sue in civil court for recovery of revenue, dues, or other amounts. There is no special notice requirements for suits by the government. So when government is following the instituting, it has no special notice requirement. Same procedure for other civil suits apply. This is 81. Okay, 82 clause 2 CPC execution against the government, where a decree is passed against the Union of India or the state or against a public officer in respect of any act of his official capacity, the execution shall not be issued on any such decree unless the decree remains unsatisfied for 3 months from the date of decree. So the limitation execution against the government can issue only if the decree remains unsatisfied for 3 months from the date of decree. This is exam tested. Okay. This is important. Exam tested execution against the government can issue only if the decree remains unsatisfied for 3 months. Okay. That is notice period. That is 2 months. Okay. This is 3 months. So this gives the government time to comply voluntarily. This is according to 82 clause 2. Suits by aliens. So 83. 83 is of CPC is suits by aliens. Alien enemies residing in India with the permission of central government may sue in any court otherwise competent to try the suit. Alien enemies ante enti Pakistan, citizens of Pakistan are type in. Think so.
Correct.
Yeah, alien friends may sue in any court otherwise competent. Alien enemies residing in India without the permission of the central government or alien enemies residing in a foreign country shall not sue in the Indian courts. So this was also exam tested 83. So filing of suits by an alien is dealt under section 83. Okay, alien friends, alien enemies. Friends aithe they can sue in any court. Enemies they can't. Others shall not sue. Okay, without the permission of central government shall not sue. Okay, 133 exemption from personal appearance. The following persons shall not be required to appear personally before a court. Who is that? The President of India, the governors of the states, plus various ranks of public officials specified in the section. That is, idanతా దేంట్లో ఉందంటే section 133 of CPC. President, governor, vice president, speaker, cabinet ministers, judges of courts, heads of the missions, etc. So these persons can be represented through authorized representatives. They are not compelled to attend the court. So this is personally. So this is also exam tested. You should remember this. ఇదంతా దేంట్లో 133. Okay. So exam tips are section 79 is government, central government ante stated as Union of India, state ante the state of whatever. Telangana, whatever. Section 80 is mandatory 2 month notice before suing the government. So 79, 80. Notice contents may on particulars of cause of action, plaintiff details, name, blah, blah, all that. Okay, relief claim. Section 80, non-compliance. Suit is defective and liable to dismissal. Is given in the court, the case of State of Bihar versus Dhirendra Kumar. 80 clause 2 is the exception. Court may dispense with the notice for urgent relief. Section 80 is binding on all the courts hearing the suits against the government. 81 suits by the government, no special notice is required. 82 is execution against the government only after 3 months from the date of decree. 83 suits by aliens, alien friends and alien enemies with permission. Section 133 is presidents and governors exempt from personal appearance. Shall I go with the questions? I think it's quite easy only.
Yeah, go ahead, please.
Yeah. Provisions regarding filing of suits by an alien under CPC is dealt under section 83. Okay.
Yeah. Alien means foreigner. So
Alien means
so just replace alien with a foreigner. So foreigners who are enemies or foreigners who are friends.
okay. So friendly aliens ante ఎవరెవరు వస్తారు
Foreigners who
allies
are, like Bhutan or Nepal or something.
Nepal and all. So okay. So second question is where a decree is passed against the Union of India or the state for done in official capacity of the person concerned under section 82 of CPC, execution shall not be issued on any such decree unless the decree remains unsatisfied of period of 3 months. 3 months
months
from the date of
date of
date of decree. Third question, which section of CPC provides exemption of the President of India, governors from personal appearance? 133. 133. So fourth is provisions of section 80 of CPC are binding on High Court, Court of Civil Judge, District Judge ante. Answer is all the above. We already read. Okay. Okay,
Yeah.
here they are given note the answer key marks D. But legally, section 80 of CPC ante notice to government before suit is binding on all the courts, including the High Court. So A, B, and C, no court without prior notice under section 80 CPC. D all of the okay. D all of the above is only the correct answer. Key orders in CPC is so this part I think is over. No, this is a new part.
14. Yeah, this is a new part.
Shall I read it?
Yeah, please. Yeah.
Okay. Key orders in CPC. This subchapter consolidates the most tested standalone orders that aren't covered in the earlier subchapters. Okay. So first is appearance and default. Order 9. Order 9 governs the appearance of parties and consequences of non-appearance. Order 9, Rule 8, where the defendant appears but the plaintiff does not. Defendant has appeared, plaintiff does not. Suit is dismissed unless the defendant admits the claim. Okay, plaintiff is only not there means obviously it will be dismissed, no? Okay. Order 9, Rule 8. Order 9, Rule 9 is bar to fresh suit after dismissal under Rule 8. Where a suit is wholly or partly dismissed under Rule 8, that is when the defendant appears but the plaintiff does not appear, the plaintiff is precluded from bringing a fresh suit on the same cause of action. So this is exam tested on top. So second time they cannot institute a fresh suit on the same cause of action. This is given in Order 9, Rule 9. Okay, we have to remember this. Order 9, Rule 9. Grounds for dismissal under Order 9. Where summons are not served on the defendant in consequence of plaintiff's failure to pay the costs. This is Rule 2. All these rules are in Order 9 only, no?
Yeah, Order 9. Basically, appearances అంటే సివిల్ కోర్టు పిలిచినప్పుడు అపియర్ అవ్వకపోతే ఏంటి, డిఫాల్ట్ అయితే ఏంటి?
ఓకే ఓకే.
చాలా సెక్షన్స్ ఉన్నాయి ఇందులో, అది ప్రాబ్లం.
చాలానే ఉన్నాయి. ఓకే. We have to read it now.
Yeah.
So grounds for dismissal under Order 9. So where the summons are not served on the defendant in consequence of the plaintiff's failure to pay costs. This is given in Rule 2. Where neither the plaintiff nor the defendant appears. This is Rule 3. Okay. Where plaintiff fails to appear when defendant appears. Rule 8. And already Rule 8 second line undi kada. So this is Order 9, Rule 8. Plaintiff will appear, plaintiff will not appear, and defendant appears. All these grounds for dismissal are valid. So this is all of the above. Rule 2, 3, and 8 in Order 9. Somehow I have to remember this. Okay, Order 9, Rule 13. Setting aside ex parte decree, where a decree is passed ex parte against a defendant, he may apply to the court to set it aside on proof that the summons was not duly served or the defendant was prevented by sufficient cause from appearing. So he only has to prove it that why he couldn't appear. That is one reason, and that summons was not duly served to him or her. Conditions 3 and beyond, example is irregularity merely in procedure are not grounds. Hence 1 and 2 is the correct answer. Irregularity in procedure options lo unte, that is not correct. We should only remember these two. Then only defendant can again apply to the court to set it aside. The joint defendants is proviso to Order 9, Rule 13, where a decree is passed ex parte against multiple defendants and the decree is of such a nature that it cannot be set aside as against the applicants only. The court may set it aside as against all the defendants. We see an example. A, B, and C are co-partners of a joint Hindu family executing a joint mortgage. Ex parte decree against all three. If anyone shows a good cause, then decree may be set aside against all because the mortgage is indivisible. Joint defendants. Where a decree is passed ex parte against multiple defendants, the decree is of such nature that it cannot be set aside as against the applicants only. Court may set it aside against all defendants. In this case, it's a joint mortgage. That's why all of them were whatever. Okay. Withdrawal and compromise. Order 23. Order 23. Order 23 deals with withdrawal of suits and compromise of disputes. Withdrawal of suits rule 1. Plaintiff can withdraw the suit at any stage with permission. Permission may be granted with or without conditions. Withdrawal without leave bars subsequent suits on the same cause of action. Withdrawal with leave, where the court grants liberty to file fresh suit, preserves the right. So, what are they saying? Plaintiff can withdraw the suit at any stage, but only with permission. Permission will be granted with conditions or without conditions. Okay. Withdrawal without leave bars subsequent suit on the same cause of action. Withdrawal with leave, where courts grants liberty to file fresh suit, preserves the right. I didn't understand this actually, this line. Without
Which
leave, withdrawal without leave bars subsequent suit on the same cause of action.
without permission of court.
Without permission of court.
Hmm.
Court. Leave means court permission.
Okay. Avuna.
But how can he withdraw without court's permission?
Withdrawal without leave bars. Okay. Correct. Withdrawal of the suit is Rule 1. Rule 3 is compromise or settlement. Parties may settle the dispute at any stage of the suit. Court records the compromise and passes a consent decree. They also have
Stop.
consent.
With
Okay.
withdrawal without leave అంటే generally absolute voluntary abandonment of legal claim.
Okay. Voluntary?
Abandonment of legal claim.
voluntary abandonment.
ఇక వాడు మళ్ళీ కనపడాడు అనమాట.
Okay.
మిస్సింగ్ ఇన్ యాక్షన్.
Okay. Sorry. Compromise or settlement is given in Rule 3. Parties may settle the dispute at any stage of the suit. Court records the compromise and passes a consent decree. The court must satisfy itself about the lawfulness of the compromise. Terms must satisfy the existing law and not to be opposed to public policy anyway. Okay. Court cannot approve the compromise that violates the law or public policy. This is compromise. This is given in Rule 3. 23 Rule 3. 23 Rule 1 is withdrawal of the suit. death, marriage, and insolvency of the parties. 22. Order 22 CPC deals with the consequences of death, marriage, and insolvency of parties on a pending suit, including procedures for substitution of legal representatives of a deceased plaintiff or defendant, effect of marriage of a female plaintiff or defendant, effect of insolvency on the suit. The question: which order deals with death, marriage, and insolvency of parties? You have to remember that. Order 22. Okay, Order 22 of CPC deals with all this death, marriage, insolvency of parties. This question was probably asked. Section 89 of CPC, settlement of disputes outside the court. అంటే ADR type ఏమో.
Hmm.
1889 CPC is inserted by the 1999 amendment, where it appears to the court that there exist elements of settlements which may be acceptable to the parties. The court may reformulate the terms, refer the matter to arbitration, conciliation, and mediation, and judicial settlement, including settlement through Lok Adalat. We read this no last sem. So the
Last
provision for
question multiple times.
Hmm.
Madhavi Chandramani.
So the provision for settlement of disputes outside court is under section 89 of CPC. This is exam tested.
Yeah.
There's no how to connect all this. Order 9, Rule 8, Rule 9, Order 9, Rule 13. Order 9 tarvata we jumped to Order 23. 23. 23 lo mali Rule 1 jadvam, Rule 3 jadvam. Then Order 23 tarvata we went to Order 22, that is death, marriage, and insolvency of parties. Then Section 89. So orders అయిపోయినాయి, we jump to Section 89. ADR. Okay. Again, we are back to orders. That is 33. So double digit 22 is death, marriage, insolvency. 2. This is 3 is suits by indigent persons. Pauper suits. Okay, it enables a person who is unable to pay the prescribed court fee to institute a suit without paying the fee, subject to court's permission. So Order 33, Rule 1, not possessed of sufficient means. SC has interpreted not possessed of sufficient means to mean that property other than property exempt from attachment and execution and subject matter of the suit. This phrase has a specific judicial gloss on top. Okay. Thus, the BCI key answer to this MCQ is none of these. This is a textbook trap. Not possessed of sufficient means. Any property other than that is exempt from attachment, execution, and subject matter of the suit. Conditions is the applicant must satisfy the court that he is indigent. It depends on him only. He only has to prove to the court that he is indigent, does not have sufficient means to pay the court fee. The court conducts an inquiry. If court is satisfied, the suit proceeds without the payment of the court fee. If the suit succeeds, the court fees may be recovered from the opposite party or the indigent person. So this is given in 33. 3. Then adjournments order. This is 17, Rule 1. Order 17, Rule 1 is adjournments. Proviso to Order 17, Rule 1, Clause 1 of CPC, no adjournment shall be granted more than 3 times. Not more than 3 times. Okay. Adjournments to a party during the hearing of the suit. The maximum adjournment per party. Per party during the hearing of suit is 3 times. You have to remember this. 3 times exam tested. The limit is intended to prevent repeated postponements that delays civil litigation, a major cause of judicial delay. So that's why they put the limit. Then summary suits. So on 22, death, marriage, insolvency, section 89, settlement of disputes outside court, then 33. Order is suits by indigent persons. Adjournment is 17, Rule 1. Order 17, Rule 1. So order 37. Summary suits. Order 37 of CPC provides the procedure for the summary suits. Summary suits are a fast track procedure for recovery of money based on a written contract, bill of exchange, hundies or promissory note designed for quick recovery in liquidated debt claims. So key features is defendant cannot defend the suit as of right. He must obtain the leave to defend from the court. Defendant must enter appearance within 10 days of the summons. Just a moment.
Yeah.
Just a moment.
Mahesh, what is this number? Order 53, yeah?
43 అన్న.
43, yeah.
సో ఎక్స్ వెనకాల ఉంది ఎవరు మైనస్ చేయాలి.
X వెనకాల ఉందా?
సో ఎల్ ఈజ్ లార్జ్ నెంబర్ కదా, లార్జ్ నెంబర్ వెనకాల స్మాల్ నెంబర్ ఉంటే మైనస్ చేయాలి, లార్జ్ నెంబర్ ముందు స్మాల్ నెంబర్ అంటే ప్లస్ చేయాలి. 50 వెనకాల 10 ఉంది కాబట్టి మైనస్ చేయాలి.
53 ఎట్లా రాస్తారు అప్పుడు?
50 వెనకాల 10 ఉంది, 40 అవుతుంది. 40 తర్వాత 3 ఉంది కదా, 43. 53 అయితే జస్ట్ ఎల్ 111 అదే ఎక్స్ తీసేయాలి.
ఓకే.
Yes, I'm back. So summary suits అయిపోయింది కదా.
Yeah.
Appealable orders is order ఇదేంటి 43 43 rule 1. Okay. Appealable orders is order 43 rule 1. Order rejecting plaintiff is appealable under order 43 rule 1 under order 7 rule 11. Order rejecting plaintiff is appealable under 43 rule 1 under order 1 second. రెండు ఉన్నాయేంటి? Only orders specifically listed in order 43 rule 1 are appealable. It's a closed list. Just remember order 43 rule 1 is appealable orders. Okay. So exam tips. So order 9 CPC's appearance and default ex parte decree. Mali order 9 rule 9 is dismissal under rule 8 bars. Fresh suit on the same cause. We read that, no? And again order 9 rule 13 setting aside ex parte. Ippudu when summons are not served. This is for the defendant. When summons are not served and sufficient cause. Then provisional to order 9 rule 13. Only order 9A. Only rules are changing. Rule 9, rule 13. Okay. Ex parte decree against the joint defendant set aside if all are indivisible. Then order 22. 2 is death, marriage, insolvency of parties. Okay. Then 23 is withdrawal and compromise. Compromise must satisfy the existing law, not violate public policies. Understood only. 89 is ADR. Arbitration, conciliation, mediation. 33 suit by indigent persons not possessed of sufficient means. Provisional to 17 rule 1 ante maximum 3 adjournments. This is related to adjournments. Okay. 17 order 17 rule 1. Then 37 summary suits 10 days for appearance. This is 43 appealable orders. Closed list including order 7. I don't know if we can remember so much. Order 43 rule 1 అయితే appealable orders అని గుర్తుపెట్టుకుంటాం. Okay. Shall I read the questions?
Yeah, please. Yeah.
Okay, question 1 is provision for settlement of dispute outside the court. దేంట్లో section
89 కదా లాస్ట్ చదువు.
89 ADR. Then second one is the word is not possessed of sufficient means. 33 rule 1 refer to lower debt of petitioner's husband, the property over which the petitioner has actual control, to sufficient property and exclude sole means of livelihood. D is none of these. None of these is the answer. ఎందుకంటే it deals with indigent persons. In that also he wrote, no, it's a trap and all. So you have to remember this. Suits by indigent persons or purpose suits uses the phrase not possessed of sufficient means. This phrase should be there. Not possessed of sufficient means. Okay. And okay, so question 3 is as per CPC 1908, decree ex parte can be set aside against the defendant if he satisfies the court that summons was not duly served, if he satisfies that he was prevented from any sufficient cause, by any sufficient cause from appearing. Then third, if he satisfies the court that there has been an irregularity in service of summons despite the fact that defendant had the notice of the date of hearing and had sufficient time to appear. Third is not correct. Fourth is without notice being served on the opposite party. So answer is 1 and 2. Okay.
Okay.
Okay. Then so దేంట్లో అంటే అది order 9 and rule 13 of CPC. Order 9, rule 13. Starting లో అన్ని order 9s చదివాం but different rules. So which of the following order deals with death, marriage, insolvency is 22. Order 22. Okay. Next one is how many times at max may an adjournment be granted as per CPC అంటే 3. చాలా స్ట్రైట్ ఫార్వర్డ్ గానే అడుగుతున్నారు కానీ we have to remember these 3 times. Okay, 3 times. The which order and rule is order 17, rule 1. Under which order of CPC? Oh, we can see the Bear Act, no?
Yeah.
What?
Yeah, అదే అంటారు. You don't need to remember all that.
Yeah, I was just thinking, okay. Under which order of CPC the procedure for summary suits? Summary suits is 37. 37 provides for procedure for summary suits. Next is suits of indigent persons is 33. Order
Yeah.
33 of CPC. Then eighth question is a suit may be dismissed under order 9 where the summons is not served upon the defendant in consequence of the plaintiff's failure to pay the costs for the service of summons, which is rule 2. Second is where neither the plaintiff nor defendant appears, which is rule 3. Where the plaintiff appears after summons has returned unserved, fails for 7 days to apply for fresh summons, rule 5. Where on the date fixed for hearing in a suit only defendant appears and he does not admit the plaintiff's claim, rule 8. So I'm going to see the Bear Act only. Rule 2, 3, 5, 8. All of the above. All of the above is the answer. Okay.
Okay.
Important cases, landmark cases are Satyadhan Ghoshal versus Deorajin Devi. Principle is defined constructive res judicata. So a matter which might or ought to have been raised as a ground of defense or attack shall be deemed to have been decided. Already that has been decided. It is defined constructive res judicata. Area is res judicata. Constructive res judicata difference ఏంటి? I forgot.
కన్స్ట్రక్టివ్ రెస్ జుడికేటా అంటే ఇప్పుడు ఆర్గ్యుమెంట్స్ అన్నీ అయిపోయినాక నేను ఆర్గ్యుమెంట్ చెప్పలేదు, లైక్ ఐ హ్యాడ్ 10 పాయింట్స్ అగేన్స్ట్ దట్ గై, ఐ ఓన్లీ సెడ్ 9 పాయింట్స్, 1 point I didn't tell, so let's reopen the case and fight.
Yes.
You can't save the best for the later and open a new case అని సుప్రీం కోర్ట్ ఆర్డర్ ఇచ్చింది ఇందులో సత్యధర్ ఘోష్.
Okay. So constructive res judicata is Satyadhan Ghoshal. So next is Daria versus State of UP. Res judicata applies to writ petitions under Articles 32 and 226.
So in this case, the guy smartly applied to అంటే బేసికలీ he was a government employee అండ్ నోటీస్ ఇవ్వకుండా చేశారు కదా సెక్షన్ 301 అవి ఉన్నాయి కదా సిపిసిలో. సో he and his petition was rejected. So then he applied to the Supreme Court saying that writ petitions are not writ petitions res judicataలో లేవు, ఒక కేసు మళ్ళీ ఇంకో కేసు వేయొద్దు అన్నారు కానీ రిట్ పిటిషన్స్లో res judicataలో ఉన్నట్టు లేవు అంటే సుప్రీం కోర్ట్ క్లారిఫైడ్ సేయింగ్ దట్ all writ petitions under Article 32, 226 fall under res judicata. So don't try to act smart అని చెప్పింది అనమాట సుప్రీం కోర్ట్. సో
So this is Dario versus State of UP. State of UP versus Nawab Hussain. Construct chala or res judicata cases. Constructive res judicata has been applied. Matters that have been raised in earlier. Okay.
Yeah.
State of
This
UP
was in
versus Nawab.
1960, res judicata, and this was again in 1977 they gave.
Okay. Okay. Next is KK Modi versus KN Modi. Abuse of the process of court. Suit filed for collateral purposes can be stated.
Yeah, I think this was basically a legal case where the rich family was fighting and they were abusing the process of the court. Tariq pe tariq, and so that the entire collateral, the land division, on the asset division, no, that can be delayed and not.
Oh, okay, okay. అనేది ఇది ఏం కాంటెక్స్ట్ లో వస్తున్నారు
ఇది
అంటే
సివిల్
సిపి
ప్రొసీజర్ సిపిసిలోనే they have written some will and they were fighting against it, saying that partition మీద who gets what.
ఓకే అంటే ఏదైనా ఆర్డర్ రూల్ సంథింగ్
They were constantly using it to abuse the process and delay. Supreme Court gave a warning.
ఓకే ఓకే నెక్స్ట్ వన్ ఇస్ సేలెం అడ్వకేట్ బార్ అసోసియేషన్ వర్సెస్ యూనియన్ దిస్ ఇస్ ఐ థింక్ famous only. Salem Advocate Bar Association versus Union of India upheld the validity of CPC Amendment Act of 2002. Mandatory written statement timelines are constitutional. Related to written statement timelines.
Written statement any days level thing after you get the summons.
Is it
30 days.
90?
30 days.
90 కదా?
No.
90 extended during some.
Extendable if the court says, sir, నేను బయట ఉన్నాను, ఒక మెమో వేసి కోర్టుని అడగాలన్నమాట పర్మిషన్.
Okay. Okay, so next is Dwarikesh Sugar Industries versus Prem Heavy Engineering. 3-part test for temporary injunction has been restated. 3-part test is prima facie case, balance of convenience, and irreparable injury. Oh, they gave this, no? This
Yeah.
is given in Dwarikesh Sugar Industries. Related
So
to
basically,
temporary.
I just go to the court, I want to put a case. Along with the case, I put a interlocutory application, which is an interim order. Sorry, factory ఆపేసేయండి. So because other party will not come, right? You're just putting a case as well as asking for an interim order. So అప్పుడు ఏంటంటే the judge has to see అసలు ఫస్ట్ ఆఫ్ ఆల్ అది ప్రైమ్ ఆఫ్ ఫేస్ కేసు ఉందా లేదా అందులో. ఓకే. అండ్ నెక్స్ట్ బ్యాలెన్స్ ఆఫ్ కన్వీనియన్స్, అంటే ఇప్పుడు కాంప్లికేట్ అవ్వకుండా ఈజీ చేయడానికి, అండ్ ఇర్రిపేరబుల్, వాడు రేపు ఆ ల్యాండ్ వేరేవాడికి అమ్మేసి కాంప్లికేట్ చేయకుండా ఆపడం అనమాట.
ఓకే ఓకే.
సో ఈ 3 గైడ్ లైన్స్ జడ్జిలకి ఇచ్చారు. నువ్వు ఇంజెక్షన్ ఇచ్చే ముందు ఈ 3 కండిషన్ సాటిస్ఫై అవుతున్నాయా లేదా చూడు అని.
ఓకే.
అంతేనా మహేష్? ఆయన నోట్స్ రాసుకుంటున్నట్టున్నాడు.
Sorry, రాసుకుంటున్నాను. Sorry, I didn't listen to this.
Yeah, I know you're writing notes.
I'm focusing in the middle, but sometimes I'm getting distracted.
Okay. So I was asking you, what is balance of convenience?
మర్చిపోయినా, చెప్పు నువ్వు మళ్ళీ.
ఇదే పని నాకు.
ఏమో.
బేసికలీ ఏంటంటే రిలీఫ్ ఇస్తే దాని అగెయిన్స్ట్ ద రిలీఫ్ ఇవ్వకపోతే వాట్ డ్యామేజ్ విల్ ఇట్ కాజ్?
What harm will it cause to the plaintiff if you don't give?
If you don't give. సో అందుకని ఇస్తారనమాట రిలీఫ్. ఓకే. నెక్స్ట్
అరే ఇక్కడ సమ్మరీస్ ఉన్నాయి కదా, రీడ్ ద సమ్మరీస్ ఓన్లీ.
యా
కింద ఇవే ఉన్నాయి కదా, సో ఐ రీడ్ దిస్.
యా
KK Modi versus KN Modi, then Raman Tech versus Solanki Traders. Held for
Raman-
attachment.
Yeah, sorry, go ahead.
Held for attachment before judgment under Order 38. The applicant must show a real and genuine apprehension of disposal of property, not a mere assertion. Reasonable grounds and credible material evidence are required. Significance sets rigorous standards for attachment before judgment applications.
బేసికలీ ల్యాండ్ అటాచ్ చేయండి అమ్మకుండా అని అడుగుతున్నారు కోర్టుకి. అప్పుడు రీజనబుల్ చూపించండి దట్ డిస్పోజబుల్ వాళ్ళు అప్రిహెన్షన్ ఉందంటున్నారు కదా. నాట్ మీరు ఫీల్ అవటం కాదు. Did he actually go to sub registrar office and book for a date or something you have to show?
Okay. So Raman Tech versus Solanki Traders. Not mere assertion, there must be real and genuine apprehension. Okay. Then Rajesh Kumar Agarwal versus KK Modi. Second appeal lies only on a substantial question of law. Sir, I'm reading the summaries. Kinda unnai kada.
Okay. Yeah, that will be
Okay,
better.
right?
Yeah.
Yeah. That's... So anyway, it's the same thing. Kada.
Correct.
So Rajesh Kumar Agarwal versus KK Modi. Held that second appeal lies only on substantial question of law. High Court must formulate the question at the stage of admission of the second appeal. Substantial question of law. So this is not substantial question of fact. Okay. So the second appeal that is given in Rajesh Kumar Agarwal versus KK Modi. Significance is this is critical for understanding the narrow scope of section 100 of second appeal. Okay. Revajitu Builders versus Narayan Swamy. Comprehensive principles for amendment of the pleadings. Advanced justice cannot introduce claims barred by limitation. Should not be oppressive or vexatious. Court has discretion balancing the justice and prejudice. Amendment of pleadings under advanced justice and has claims barred by limitation. Obviously, should not be oppressive or vexatious. Okay. Court has discretion balancing justice and prejudice. This is a foundational case on amendment jurisprudence under Order 6, Rule 17. Revajitu Builders versus Narayan Swamy related to amendment of pleadings. State of Bihar versus Dhirendra Kumar. Section 80 notice is mandatory before, we just read this now, before filing the suit against the government. Non-compliance makes the suit premature and liable for dismissal. Establishes the absolute mandatory nature of Section 80. 80 notice before filing a suit against the government. Pandurang versus Shanti Bai. The 12-year limitation period for execution of the decree, Article 136 of Limitation Act is strict, cannot be extended on equitable grounds. Cannot be extended, it is strict. Until 12-year limitation period is strict. Strict nature of the execution limitation, the distinction between substantive and procedural law. Panduranga versus Shanti Bai. Okay. Siraj Ahmed versus Wahid Ali. A counterclaim need not relate to the subject matter of the original suit. So it can be independent cause of action and any relief can be claimed. Counterclaim need not relate to the what we read now, set of counterclaims. So counterclaim need not relate to the subject matter of the original suit. Independent cause of action kuda undachu and any relief can be claimed. So this expands the scope of counterclaims under Order 8, Rule 6A of CPC. It's given in case law of Siraj Ahmed versus Wahid Ali. Nawabganj Sugar Mills versus Union of India. Section 115 of CPC revision is limited to jurisdictional grounds and procedural errors. The High Court cannot reappreciate the evidence or substitute its judgment for that of the trial court. Restricts the scope of revision. Revision is restricted. The scope of revision is restricted. As according to Section 115 of CPC preserves the finality of factual findings. Limitation aspects of CPC. While the Limitation Act 1963 is a substantive law, CPC provides a procedural framework for enforcing time-barred remedies. Understanding this interaction is crucial. Recovery of specific immovable property, Section 6 of CPC of the Specific Relief Act 1963, read along with CPC, provides that a person dispossessed without the consent of immovable property otherwise than in due course of law may recover the possession of the suit instituted within 6 months from the date of dispossession. What is the meaning of this? It provides that a person who is dispossessed without the consent of immovable property, otherwise than in due course of law, may recover the possession of suit. Okay, fine. Instituted within 6 months from the date of dispossession. So, recovery of specific immovable property under Section 6 of Specific Relief Act must be obtained within 6 months. Okay.
Okay.
Recovery of specific immovable property. Then suit institution and limitation. Section 26. Suit is instituted from the date of presentation of the plaint to the court. Date of institution is critical for determining whether the suit is within the limitation period as prescribed in limitation. Why date of institution of the suit is important? Because they correlated with the limitation period. So whether it is within the limitation period or not. Condonation of delay is section 5 of CPC of Limitation Act. Court may condone the delay in filing appeals. నేను గుర్తులేదు నాకు condone the delay అంటే something is there, no? Condonation.
అంటే బేసికలీ ఫర్ ఎగ్జాంపుల్ సంబడి గాట్ ఎ డిగ్రీ దాన్ని ఛాలెంజ్ చేయాలి 6 మంత్స్లో. ఆ 6 మంత్స్లో ఛాలెంజ్ చేయలేదు. చేయనప్పుడు యూ కెన్ గో టు ద కోర్ట్ అండ్ సే ద రీజన్ ఐ డింట్ ఛాలెంజ్ ఈస్ బికాస్ నాకు తెలవలేదు ఆర్ లాయర్ గేవ్ ఎ రాంగ్ అడ్వైస్ ఆర్ ఐ వాజ్ సిక్ and all these things, and you have to tell the judge. So judge will say, okay, he'll condone the delay and he'll give you a fine, and then he'll accept the suit or not.
Oh, okay.
That is called
So this
condonation.
is after the limitation period.
After the
Applications filed after the limitation period.
Correct.
If sufficient delay or something is given. Okay. Sorry. Section 5 of Limitation Act of 1963 law, court may condone the delay in filing appeals, applications or certain proceedings if applicant shows sufficient cause for not filing within time. So sufficient cause is important. Applies to appeals and applications, not to original suits. Not to original suits. It applies only to appeals and applications. Sufficient cause is decided based on the facts. So court has discretionary power in this. There is no fixed 90-day extension rule of in CPC or Limitation Act. The court exercises discretion on a case-to-case basis. This is given in Section 5 of Limitation Act. Condonation of delay. Okay. And bar due to pending suit. Section 10. While the earlier suit is pending, no fresh suit on the same cause can be filed. However, the limitation continues to run during the pendency of the earlier suit. A fresh suit may be barred if filed after dismissal of the original suit beyond the limitation period. అంతే కదా. Limitation continues to run. Okay. Bar due to pending suit. Fine. Limitation for the execution. Decree can be this we read na 12 years from the date of decree. This is strict period. No case law ఏంటంటే Panduranga versus Shanti Bai. No general extension provision. Amendment and limitation period. Just a moment. Yeah. Amendment and limitation అంటే the amendment to the pleadings cannot introduce a claim barred by limitation. Exception is where the amendment relates back to the original date of institution. Example where the amendment is a correction of names or particulars and cause of action is the same. ఈ అమెండ్మెంట్ టు ప్లీడింగ్స్ దేంట్లో వచ్చింది ఏదో ఉంది కదా
ఇందాకే మనం
కేసులో యా
రేవిజిత్ బిల్డర్స్ ఇందాకే చదివారు కదా.
రేవాజిత్ కరెక్ట్.
కాంప్రిహెన్సివ్ ప్రిన్సిపల్స్.
Okay, exam tips is section 6 of Specific Relief Act to be read with CPC, recovery of specific movable property within 6 months of dispossession. So ఇక్కడ స్పెసిఫిక్ రిలీఫ్ యాక్ట్ ఒకటి యాక్ట్ చెప్తున్నారు, ఇంకా లిమిటేషన్ యాక్ట్ గురించి చెప్తున్నారు ఇన్ దిస్ పార్ట్. Section 26, suit instituted from the date of presentation. Condonation of delay, Section 5 of Limitation Act. And It applies only to appeals and applications, not to original suits. 10 ఏంటంటే the limitation continues to run during the stay of the suit. Fresh suit may be part. Article 136 of Limitation Act, 12-year strict limit for execution of the decree. The amendment cannot introduce claim barred by limitation. It's the general rule. So shall I read the questions?
Yeah, sure.
Okay, recovery of specific immovable property may be obtained by CPC within what period? 6 months. Just read it, no? 6 months.
Yeah.
So that's it.
Yeah,
Only one
that's it.
question.
Yeah, limitation లో ఒకటే క్వశ్చన్ ఉంది. And which was asked in 15, maybe 16 actually. So మిగతాదంతా ఇది basically this is like a summary of what we have studied.
Okay.
And important distinctions ఉన్నాయి కదా, res judicata, set of temporary appeals, revisions, తేడా ఏంటి, అండ్ లైక్ జ్యూరిస్డిక్షన్ కి ఏ సెక్షన్, ఇన్స్టిట్యూషనల్ సూట్ కి ఏంటి, ప్లీడింగ్స్ కి ఏంటి, క్విక్ రెఫరెన్స్ ఆఫ్ ఆల్ ద సెక్షన్. And then what are the common pitfalls when overlooking the 12-year limitation period? We're just reading about this, right? Okay. Second appeal lies in the question of fact. It does not lie in the question of fact, right? Question of fact and High Court. So all that we have learned. So you can go through this, and then topics covered. These are all the topics which we have covered, including the landmark cases. And yeah, that's where it ends. So tomorrow we'll get into BNSS.
Okay.
All right.
So we've finished CPC form.
Yeah, we finish CPC. At least what happens is when you do this, right, there are some structures that are formed in your brain. So when you read it again, it becomes very easy. So it's like a revision.
Oh no.
First time takes a lot of time. So my thing is, if you see, CPC is very big. First 4 chapters are very, very big. Second chapters are it is like 77 pages, right? But
Oh no.
the chapter is like 20-30 pages. Only 20 questions. ఇందులో 100 questions ఉన్నాయి. Constitution లో 120 questions ఉన్నాయి. అట్లా. So it will take time for the first 4, but after that, I think one day will be enough for all of the topics. I think once we finish this, then we can do a revision on your own. That's what I thought. Okay. Thank you, Mahesh and Sai Baba Garu. And I'll post this video. Okay. After editing.
Yeah.
Thanks, Venugar. Thanks, Venugar.
అయ్యో బలో
Thank you, sir. Thank you.
ఎటకారం వద్దులే కానీ వెళ్ళి ఇంకా.
థ్యాంక్స్ అందరికి.
ఓకే ఓకే. హాయ్. సరేనండి, బాయ్.
బాగా